meaning they are deductible to investors as a financing mechanism to refinance junk bonds which were used up front to start the project and make and presumably cover the cost of building the line all the way from Miami to Orlando. I have not talked to a person who doesn't believe that's a very tenuous economic proposition, and the fear is that that it will fail. And who holds the bag, and does the taxpayer hold the bag, as taxpayers have held the bag on things like banks, which fail. And so the only, in the opinion of a lot of people, but the only thing we can do is work against the financing to make sure that if it is passed and the money is raised and All Aboard Florida fails, that we're not on the hook as taxpayers. We can't stop it, but we can certainly suggest that whoever approves this thing ought to be very circumspect in terms of putting money against a good economic proposition and not a proposition that was set up for a different reason, mainly to enhance the value of the real estate that FEC owns at the various locations where a considerable amount of building will take place. Skip, I don't know, and you probably do, has any other barrier island community, as far as you know, had a resolution?
Jupiter Island adopted a resolution.
Yes, and that resolution was over a year ago.
Yes.
And it was very specific to circumstances north of West Palm, which is the trains have to go over old bridges. Some of the bridges are actually almost 100 years old. And you're going to be adding considerable amount of more weight, and particularly the bridges are going to have up and down ad nauseum. And we saw last month a terrible incident where the bridge went up, but it didn't come back down. And so all the trains that were approaching had to stop, and they all stopped in Tequesta, and they completely covered Tequesta from one end to the other, one long train that people couldn't get across the tracks and get to their to the hospital, the school, or wherever they were going. And that could happen to us when all is said and done. It could happen if there is a disaster somewhere along the line. The trains are just going to keep coming north or going south, whichever direction, and then back up. And so we'll have trains stuck on the crossings that we need to get to the hospital or wherever. So what the resolution that we're proposing is, I wouldn't call it plain vanilla, but it is limited by what we can expect to accomplish, as opposed to what we wish we could do, and wishes don't get you very far. So this 2 pages which the commission has read were actually submitted to the city of Delray for information purposes, and they decided to have a resolution very similar to ours, and it's being drafted right now by the city attorney. Now, Delray has another different situation in that their mayor sits on the MPO that basically approved All Aboard Florida in the first place. So from a political point of view, on the one hand, he supports All Aboard Florida as an idea. On the other hand, he recognizes that Delray, probably more than any downtown municipality, is going to be affected, particularly on Atlantic Avenue, where you can imagine what would happen if a train was barreling down at 79 miles an hour on an easily crossable, but no matter what stanchions they put down, people are going to just think I can beat the train and
32 more times a day.
32 more times a day.
It goes from 20 to 52.
Yeah. So
How
it's
do they deal with the traffic just in Delray?
well, they finally decided that they have to have a comprehensive traffic plan, and it's built around not just All Aboard Florida, but other major developments that are either underway or still contemplated for the downtown area. I think the other thing that we really need to bear in mind is that and it's actually written into our resolution. I think the game plan is to take two competing railroads. That is the old Seaboard, which is now called CSX. And that's where the, what's the train that goes down to Miami?
Tri-Rail?
Tri-Rail, sorry.
Tri-Rail?
Tri-Rail is on those lines, on the old Amtrak, the old Amtrak. And then FEC is currently just freight, but wanting to become freight and passenger. There's a third piece of the puzzle, which are true commuter trains. And you would argue that the true commuter trains, which might be only one car, going up and down the FEC tracks from West Palm Beach to Miami and stopping in Delray and Boynton Beach and is probably a good idea. And the belief is that once they've got this thing up and running, there'll be some horse trading. And some of the freight trains will go over onto the onto the Seaboard tracks, and then some of the commuter trains will come over onto our tracks. And they actually have designed ways that they can get off and back on in areas where it's less than a mile from one track to another. So I think the long-term prospect for South Florida is that we're going to have passenger trains again, as we once did. It was the only way we could get here. But they're going to not be what we are dealing with today. It's going to be some forms of compromises that allows those tracks, which are valuable pieces of property, to be used more effectively to move people and freight. Freight is going to continue to grow. As citizens of the United States, we've got to hope that's the case, because that says we're a robust economy. But it's going to be, there's going to be an awful lot of train traffic. And, you know, these towns were built 100 years ago when there was no other way to get here. So anyway, what I'm proposing is a resolution. I did it for discussion only. You may or may not agree with what's in it, but I felt it was easier to edit than to create. And if you are comfortable with it, we probably should do something, because what will happen as a resolution, which is a statement of policy by the community, that it will eventually get itself to the people who are collecting all of these things, and it will eventually show up at that April 20th meeting in Tallahassee, where the subject of All Aboard Florida financing will be discussed. The belief is that FDOT has given them till July 1 to get their financing package in hand. The belief is that's highly unlikely it's going to happen unless the governor wants it to. And we're not absolutely sure what the governor's position is on this project. But I know for one thing, he is not going to approve a project that looks to be a lousy economic proposition, because he doesn't want to saddle the taxpayers with the consequences of government.
Any comments or questions? Mr. Ganger, I think it's a good resolution. It's not strident. It doesn't take positions that are really not only unenforceable but unrealistic. And it raises the concerns that really any responsible public official should be concerned with. I'd be in support of this resolution.
It addresses everything. I think that the average citizen in the town of Gulfstream should be worried about traffic, crossings, noise, and obviously debt and taxpayer relief down the road, which hopefully will be avoidable. So I'm in support of it as is.
I think you did a lot of work on it, and it expresses a lot of those things. It's too bad it can't be stronger, but as you said, it's a private venture, and this is the most we can do.
I agree.
You agree? Seems like we're all in agreement.
Good.
You want me to
Stop
read
it.
it by title? Shall I read it by title?
Sure.
A resolution of the Town Commission, Town of Gulfstream, Palm Beach County, Florida, expressing concern for the All Aboard Florida business plan, asking local, state, and federal officials to assist the town in mitigating said concerns and providing for an effective date. And that's being presented for your consideration the 10th day of April, 2015.
Resolution's been proposed relative to All Aboard Florida business plan. Is there a motion to approve?
How about if I say motion to approve? Would that make you feel good?
Second.
Read it.
Commissioner Ganger?
No number. Did you have a number?
Yes, I do. It's 15-2, sorry.
Thanks.
Commissioner Ganger?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwine?
Yes.
Mayor Morgan?
Yes, and please, everybody stay afterwards to
Yes.
sign these various resolutions. We have one other item. Mr. Randolph?
Yes, two brief items. The,
Yeah. Do you know what, can I have a question before we're done? You said the resolution was 15-2? Wasn't the last one 15-2?
That was ordinance.
It's, okay, it's an ordinance, I'm sorry. I'm confused now. That's fine. I just wanted to clarify it before we went on. Go ahead.
Mr. Randolph?
as you know, there is a case pending, Martin O'Boyle and Asset Enhancement, Inc. versus Town of Gulfstream, Scott Morgan, John Randolph, Robert Sweetapple, and Joanne O'Connor. In regard to that case, the town's insurance carrier denied coverage. However, my firm's insurance carrier accepted coverage in an effort to keep expenses down for the town and not have two sets of attorneys dealing with each, i.e. my firm and the town. I've asked our carrier if they would use Johnson and Selmo, etc., who has represented the town of Gulfstream in the past in regard to these lawsuits, and they have agreed. So I am asking the town to, because we have a $50,000 deductible on that policy, to approve the payment of attorney's fees from the town for that case. I sincerely doubt it will reach the amount stated, but for purposes of allowing Johnson and Selmo to go forward with presenting their bills, which will be on behalf of Joanne O'Connor, myself, and Scott Morgan, and Town of Gulfstream, I would request that the town commission authorize the payment of our attorney's fees up to the amount of $50,000 deductible to the extent applicable. And as I say, I don't think it's going to reach that, but I would keep you informed as to, from month to month, or however you wish, in regard to how the attorney's fees are progressing on that.
Well, lawyers are sued only because they represent us, and it's a strategy and a tactic, and it's, in my opinion, our obligation, since we're defending the case anyways, to protect our lawyers. So I would be in favor of this.
We did pass a similar resolution or approval of an expense for, I believe it was for Attorney Sweetapple.
Yes, you did.
For 25,000.
Yeah.
You have a higher deductible. What happened?
They're cheap, that's why.
Lower premium.
Lower premium.
Bigger firm.
Yeah.
Is there a motion to?
Motion to approve the request for a $50,000 deductible cap, I guess, on our participation with our attorneys on this matter.
I'll second it.
Rita?
May I comment, Mr. Chairman?
Yes, of course.
Oh, thank you. I'm assuming this is different than the $25,000 to pay Mr. Sweetapple's deductible for his case. This is great. I don't know what this case is about. Is this the sunshine violation?
Yes.
Okay, because I haven't talked to any of these people. I know there's been a lot of discussion about legal fees, and we're gonna have a workshop to see, to prioritize that, and I hope that workshop gets published like the other on the website, but I'm just concerned that public money is being used to pay a deductible, because it's not really a deductible if the town's paying it, is it? It's like a second insurance company. But I'm just concerned the town is using public money to pay for Mr. Morgan's alleged sunshine violation. Is that proper? I mean, I don't know. I guess you guys can do anything you want that's legal, but I just thought, is that a good use of public money?
This is the case you know nothing about, isn't that what you said?
I don't recognize this, I think it's called the style,
Okay.
the top thing.
Anything else to say?
I'm just questioning the wisdom of using public money, another $50,000 when so much legal fees has been consumed when all these things could have been dismissed so inexpensively, but I just question the wisdom of it.
May I clarify, Mr. Mayor? This deals with the representation of Joanne O'Connor and myself, not Scott Morgan or the town of Gulfstream. Anselmo Johnson is handling that matter on the town's behalf and on your behalf. This is to the extent that we incur our own attorney's fees up to this amount, we would request reimbursement from the town. And again, I don't think it's.
The same way to represent all parties, there's.
Yes, otherwise we'd have duplicate attorneys.
Considerable efficiencies and cost savings. Okay, we have a motion and a
Thank you,
second.
Mr. Randolph, I appreciate that
Read it.
clarification.
I'm sorry,
May I make
I'm sorry, there's another
a
comment.
very brief statement? May I make a very brief
Of
statement?
course.
Thank you. As a taxpayer of Gulfstream, I applaud your position on all of the lawsuits in which the town is currently engaged. I applaud the taxation in order to raise the funds to continue with these cases, and I believe that it's essential and that any reasonable person would want our council to be protected. Thank you.
Thank you. All right, we have a motion and a second. Read it.
Commissioner Ganger?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Absolutely, yes.
Mayor Morgan?
Yes. Mr. Randolph?
Yes, the next issue is in regard to the O'Hare/O'Boyle litigation. As you may know already, that in defense of various public records lawsuits filed against the town by Mr. O'Boyle and Mr. O'Hare, the council, as part of their strategy, has had to file, in addition to filing answers and affirmative defenses, has filed certain counterclaims and joinder of parties relevant to those lawsuits. Mr. O'Hare and Mr. O'Boyle have challenged the town's attorney's authority to file counterclaims and joinder of parties in these actions, absent being given the authority by the town commission to do so. We believe that we have that, the council has that authority based upon the direction that you have given us. However, in light of the challenge that has been made, in the event you as a commission agree, we are seeking confirmation that the town's attorneys have been given and in the future have the authority to bring appropriate counterclaims against any and all parties deemed by the town's attorneys to be involved or culpable in regard to matters relating to the pending litigation, including joinder of parties. I'm requesting that you consider that matter, and if you agree to give us direction that you indeed confirm that and that we have the future right to file these counterclaims and joinder of parties. It's a little difficult. You know, counterclaims are filed, as the attorneys will know that are here, at the same time, not as a separate time when you as filing answers and affirmative defenses. And so it would be rather difficult, I believe, and would hamper the ability of your counsel to represent you in these cases, to have to come back before you and ask if they can file a counterclaim or a joinder of parties in regard to the filing the answer and affirmative defenses. So all we're asking for is a confirmation of that, as already has been done in the past by council, and future direction that the council can do the same.
I believe it has been done in the past, and I believe it's implicit in attorney's representation to file counterclaims, joinder of parties, and any other affirmative defenses in response to a complaint to defend a client. But to the extent that that has been challenged, by all means, I think we should affirmatively grant that authority to our council.
I'd like to move to affirmatively grant that authority to you and your partner.
So you're confirming that we have had that authority in the past and then to do so in the future.
Yes.
Second.
May I
Mr.
comment?
O'Hare, you want to make a comment?
Just briefly, sir. Mr. Randolph says that counterclaims are filed at the same time as affirmative defenses, but in the counterclaim on my public record request to obtain a boundary map, which I was denied, the counterclaim was filed 7 months after the counter defenses, or the defenses were filed. So just a clarification.
Thank you. There's been a motion and a second. Read it.
Commissioner Ganger?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. Any other comments by the commission? If not, this meeting is adjourned.
Not 3 o'clock.
Got night meeting.
No, 5.